Daniel Carter had lived in Willow Creek Estates for nearly a decade. His home was his pride, not because it was the biggest or fanciest, but because every improvement was done with his own hard-earned savings. When his old wooden windows began, sticking in the summer and leaking in the winter, Daniel knew it was time for a change. He spent months researching replacement options, attending HOA design committee meetings, and even walking the neighborhood to see what styles other homeowners had used. Finally, he found the perfect set, double-paned, energy-efficient, with a clean white trim that matched the community's guidelines. Before a single pane was ordered, he submitted the official request form. A week later, the HOA's architectural committee approved the design in writing, a signed and stamped letter dated and filed. Daniel even kept a copy in a folder marked Home Projects, 2017. When the contractor finished the installation, Daniel stood in his living room and admired the sunlight streaming through the glass. It was warmer, quieter, and the drafts were gone. It felt like progress, the kind you could be proud of. 2 months later, a thick envelope appeared in Daniel's mailbox with the HOA's seal in the corner. He thought it was a routine update or maybe a newsletter. Inside was a formal violation notice. It claimed his new windows did not meet the community's design standards and imposed a fine of $12,000. Daniel read the letter 3 times, certain he had misunderstood, but the words were clear. The next morning, Daniel marched to the HOA office, folder in hand, approval letter on top. He placed it on the counter and calmly explained the situation to the receptionist, who called the HOA president. The president barely glanced at the paper before saying, "That approval was, issued in error. The style is non-compliant. You're still responsible for the fine." Daniel's jaw tightened. "So your mistake cost me $12,000? he asked. "That's the rule," the president replied, unmoved. At first, Daniel believed the problem could be resolved with reason. He attended HOA board meetings, presenting the same documents over and over. Every time, the vote was the same: fine upheld. As weeks passed, late fees began to stack onto the original fine. The number grew to $15,000, then $18,000. He was warned that if he didn't pay, the HOA could place a lien on his property. Daniel felt the weight of frustration pressing down on him. He began keeping a meticulous log, every phone call, every email, every conversation. He bought a small voice recorder and started taping board meetings. He wasn't sure yet how he'd use this information, but something in his gut told him to be ready. One cool autumn evening, Daniel was getting his mail when his elderly neighbor, Mr. Harper, approached. Harper had served on the HOA board years before and knew the rules inside and out. "Daniel," he said quietly, "their approval letter is legally binding. State law says once they approve a project, they can't revoke it without your consent. They don't want you to know that." That night, Daniel pored over state housing statutes. Harper was right. The more Daniel read, the clearer it became. The HOA had overstepped, and he had the proof to show it. The next morning, Daniel began meeting with attorneys. Most told him it would be a long, uphill battle, but one, a sharp, confident lawyer, named Rebecca Sloan, looked over his folder and said, "You've got them. This isn't just about removing the fine. This is about damages." It took nearly 5 years of legal maneuvering before the case finally went to trial. By then, the HOA's arrogance had only grown. They arrived in court with thick binders and a team of attorneys. Rebecca stood calmly before the judge, holding up one single sheet of paper, the original approval letter. She explained how Daniel had followed every rule, obtained every signature, and relied on the HOA's own authorization before spending thousands of dollars on the renovation. When the HOA president tried to argue, the judge raised a hand. "This," he said, pointing to the letter, "is a contract. You cannot punish a homeowner for complying with your own written approval. The fine was improper, and the defendant is entitled to damages." The courtroom went silent. The president's face paled. A few weeks later, a certified envelope arrived at Daniel's home. Inside was a formal settlement agreement and a check for $75,000. It covered the original fine, legal fees, and compensation for the stress and harassment he'd endured over the years. Daniel stared at the signature at the bottom, the HOA president's name written in neat black ink. The same person who had once told him, "That's the rule," had now been forced to sign away more than 6 times the amount they'd tried to take from him. Daniel didn't post about it online. He didn't make speeches or tell the neighbors every detail. Instead, he took his wife out for a quiet dinner at their favorite restaurant. On the way home, they drove past the HOA office. The lights were off, the parking lot empty. Daniel glanced at the building and felt a deep, steady satisfaction. "Worth the wait," he said softly as they turned into their driveway, their home, their windows, and their dignity intact.